Minnesota Senator Al Franken has introduced a bill that would require the NSA to disclose more information about its collection of phone records and other data. He chaired a hearing earlier this week with government officials who expressed concerns about the legislation and a Google executive who favors the bill.
Yeah. Bad luck. Okay. Are you ready?
Yeah.
This hearing will come to order. Welcome to the Senate Judiciary Subcommittee on Privacy, Technology, and the Law. The subject of this hearing is my bill, the Surveillance Transparency Act of 2013. I'm proud to say that 2 weeks ago I reintroduced this bill with the support of my friend and colleague, Senator Dean Heller of Nevada, who we'll be hearing from in just a moment. This bill is urgently necessary. Americans understand that we need to give due weight to privacy on the one hand and national security on the other. But Americans are also naturally suspicious of executive power, and when the government does things secretly, Americans tend to think that that power is being abused. This is exactly the place where congressional oversight is useful and necessary. For months now, there has been a steady stream of news stories about the NSA surveillance programs, and yet right now, by law, Americans cannot get really the most basic information about what's going on with these programs. Consider this. It's been months since the PRISM program and the telephone call records program were revealed to the public, and yet, to this day, Americans don't know the actual number of people whose information has been collected under those programs. They don't know how many of those people are American, and they have no way of knowing how many of these Americans have had their information actually seen by government officials as opposed to just being held in a database. The administration has taken good steps in good faith to address this problem, but I'm afraid that these steps are too little and that they are not permanent. And so Americans still have no way of knowing whether the government is striking the right balance between privacy and security or whether their privacy is being violated. I believe there needs to be more transparency. I've written a bipartisan bill to address this. It will require that the NSA disclose to the public how many people are having their data collected under each key foreign intelligence authority. It would make the NSA estimate how many of those people are American citizens or green card holders, and how many of those Americans have had their information actually looked at by government agents. My bill would also lift the gag orders on internet and phone companies so that those companies can tell Americans general information about the numbers of orders they're getting under each key authority and the numbers of users whose information has been produced in response to those orders. Right now, as a result of those gags, many people think that American internet companies are giving up far more information to the government than they likely are. The Information Technology and Innovation Foundation estimates that American cloud computing companies could lose $22 to $35 billion in the next 3 years because of concerns about their involvement with surveillance programs. The analytics firm Forrester puts potential losses much higher at around $180 billion. A few companies have litigated and secured permission to publish limited statistics about the requests that they get, but again, this is too little and it's not permanent. My bill would permanently ensure that the American people have the information they need to reach an informed opinion about government surveillance, and it would protect American companies losing business from misconceptions about its role in these programs. I'm pleased to say this bill is the leading transparency bill proposal in the Senate, supported by a strong coalition of tech companies and civil liberties groups. The version as introduced gained the support of 12 senators, including the chairman of the full Judiciary Committee, Patrick Leahy. I anticipate that we'll soon be adding our original supporters onto the new bipartisan bill, hopefully with some additional support as well. The purpose of this hearing is to make the case for this bill and to improve it by getting the feedback of top experts in the administration, privacy groups, and in the private sector. I've specifically asked the Office of the Director of National Intelligence and the Department of Justice to provide candid comments on this bill, especially any concerns that they have. I've already added provisions in the bill to protect national security, but I want to know any further concerns that they have. I suspect that I'll agree with them in some cases and disagree with them in others. In those cases, I want to have an open exchange about the disagreements. That said, I want it to be clear at the outset that I have the utmost respect for the men and women of our intelligence community. I think they are patriots, and I think they have and do save lives. I look forward to starting this conversation. With that, I will turn to our ranking member, Senator Flake. Senator?
Thank you, Senator Franken, and appreciate those who will testify today. This is the first subcommittee hearing we've had. I suppose that given the rate at which technology develops, this will be an important subcommittee as we go along to try to strike that balance that you talked about between privacy issues, between transparency and national security. I look forward to this hearing to see if we have this legislation, if this bill before us actually strikes that balance. And I come to this hearing with an open mind and realize that this is really a struggle that the Congress goes through continually. I was around when the Patriot Act passed. There were issues with that. We authorized it, but then sunsetted a lot of the provisions that were that we needed to deal with later, and then dealt with those later. We are continually, with technology developing, continually trying to strike the right balance. The security leaks that we've had in the past couple of years, and certainly in the past couple of months, have undermined the confidence that the public has in what we're doing here, and that I think is damaging. And so I look forward to more transparency, whether in this legislation or some version of it, or in some other way, to make sure that people are confident that that their public officials have transparency in mind and the best interests of the public in mind here. So with that, look forward to hearing the testimony.
Thank you, Senator Flake. This is the first hearing of this subcommittee in this Congress, and I am happy to have you as a new ranking member of this subcommittee. It's now my pleasure to introduce my friend and colleague, the Senator from Nevada, Senator Heller. 2 weeks ago, Senator Heller and I introduced an improved version of this bill. I think that Senator Heller's support for this bill and his presence here speaks to the fact that transparency is a bipartisan issue. Some of the best work in the Judiciary Committee on the issue of transparency has come from our chairman and others on our side, working with folks like the ranking member, Senator Grassley, and Senator Cornyn, and many others. This bill is an effort to continue that tradition. Senator Heller.
Thank you, Mr. Chairman, and to Senator Flake. I'm real pleased to be here today. I'd like to thank you also for inviting me to testify. I want to thank you for holding this hearing, and Mr. Chairman, I want to thank you for your leadership that you bring to the table on transparency to the bulk collection programs run by the NSA. This is a strong bill, rooted in the belief that Nevadans, Minnesotans, and all Americans should be provided access to reports that explain the personal communication records that the government is collecting and how many Americans have had their information caught up in that collection. By now, most people are aware of the bulk collection practices by the federal government that are authorized by sections of the Patriot Act and sections of the FISA Amendments Act. I am confident the full Judiciary Committee will have a robust debate on the bulk collection practices and whether or not this program should continue. I believe that the bulk collection program mostly authorized under Section 215 of the Patriot Act should come to an end. Subsequently, I agreed to join with Judiciary Chairman Leahy as a principal sponsor with Senator Lee and Senator Durbin on the USA Freedom Act. While there is disagreement on whether this program should continue, I am confident all of us can agree that these programs deserve more transparency. This is why I joined Senator Franken to introduce the Surveillance Transparency Act of 2013. This legislation would call for reports from the Attorney General detailing the requests for information authorized under the Patriot Act and the FISA Amendments Act. The reports would detail the total number of people whose information has been collected under these programs, how many Americans have had their information collected, and also how many Americans actually had their information looked at by the NSA. Furthermore, this legislation would allow telephone and internet companies to tell consumers basic information regarding the FISA court orders they receive and the number of users whose information is turned over. The principles outlined in this bill to increase transparency for Americans and private companies would clear up a tremendous amount of confusion that exists with these programs. That is why transparency reform is included in multiple NSA reform proposals, including the Intelligence Oversight and Surveillance Reform Act, introduced by Senator Wyden, the USA Freedom Act, introduced by Chairman Leahy and myself, and the FISA Improvement Act, introduced by Senator Feinstein. Mr. Chairman, while positions on the bulk collection program may differ, many of us agree on the need for more transparency. That is why I urge support for the Franken-Heller legislation before this subcommittee today. We are talking about millions of Americans' calls that are collected and stored by the NSA. Americans should have access to some basic information regarding the amount of data collected and what is actually being analyzed, so that my constituents, your constituents, can determine for themselves whether they believe this program is worthy to continue or not. And with that, again, thank you for the opportunity to have me testify. Mr. Chairman, I want to repeat, thank you very much for your leadership on this issue. Thank you.
Thank you for yours, Senator Heller. I'm looking forward to working together with you on this as we go through this process. You're excused, and your panel is adjourned. I'd now like to introduce our second panel of witnesses. Robert Litt is the General Counsel of the Office of the Director of National Intelligence. He was confirmed by the Senate by unanimous consent in 2009. Before joining the ODNI, Mr. Litt was a partner with the law firm of Arnold and Porter. From 1994 to 1999, Mr. Litt worked in the Department of Justice, where he served as Deputy Assistant Attorney General in the Criminal Division, and then as Principal Associate Deputy Attorney General. Brad Wigman is a Deputy Assistant Attorney General for National Security at the Department of Justice. He has served as a career government attorney for the past 17 years, including positions at the State Department, the Department of Defense, and the National Security Council. His government service has focused on national security and international law, including counterterrorism, intelligence activities, and counter-proliferation. Welcome, gentlemen. ODNI and DOJ have submitted joint written testimony, which will be made part of the record. You each have 5 minutes for any opening remarks that you'd like to make. Mr. Litt, would you begin?
Thank you, Mr. Chairman, Ranking Member Flake, Senator Blumenthal. Thank you for the opportunity to appear before you today to discuss this very important issue of how best to inform the public about sensitive intelligence activities consistent with the needs of national security. And I want to say that I appreciate the support that you have shown for the intelligence community over the last few months in their activities. The recent unauthorized disclosures have led to a public dialogue about intelligence collection activities, particularly those conducted under the Foreign Intelligence Surveillance Act. But it is critical to ensure that that public dialogue is grounded in fact rather than in misconceptions. And therefore, we agree that it's important to help the public understand how the intelligence community uses the legal authorities that Congress has provided it to gather foreign intelligence and the vigorous oversight of those activities to ensure that they comply with the law. As you know, some months ago, the President directed the intelligence community to make as much information as possible about certain intelligence programs that were the subject of those unauthorized disclosures available to the public, consistent with the need to protect national security and sensitive sources and methods. Since then, the Director of National Intelligence has declassified and released thousands of pages of documents about these programs, and we're continuing to review documents to release more of them. These documents demonstrate that these programs are all authorized by law and subject to vigorous oversight by all three branches of government. And it's important to emphasize that this information was properly classified. It's being declassified now only because, in the present circumstances, the public interest in declassification outweighs the national security concerns that required classification. But we still have to take those national security concerns into account. In addition to declassifying documents, we've also taken significant steps to allow the public to know the extent to which we use the authorities under FISA. And I agree with both of you and Senator Heller that it is appropriate to find ways to inform the public about this consistent with national security. Specifically, as we set out in more detail in our written statement for the record, the government is going to release on an annual basis the total number of orders issued under various FISA authorities and the total number of targets affected by those orders. Moreover, recognizing that it's important for the companies to be able to reassure their customers about how often, or more precisely, how rarely, the companies actually provide information about their customers to the government, we've agreed to allow them to report the total number of law enforcement and national security legal demands they receive each year and the number of accounts affected by those orders. We believe that this approach strikes the proper balance between providing the public information about the use of the legal authorities and protecting our important collection capabilities, and I'd be glad to discuss that with you in more detail as we move ahead. Turning to the Surveillance Transparency Act of 2013, which you and Senator Heller have co-sponsored, we've reviewed the bill and we share the goal of providing the public greater insight into the government's use of FISA authorities. And we appreciate the effort that you've made in this bill to try to accommodate transparency and national security. We've had good discussions with your staff about that bill. Many of the bill's provisions are consistent with the steps we've taken so far, and we support them. But we do continue to have concerns that some of the provisions raise significant operational or practical problems. These concerns are summarized, are set out in more detail in the written statement for the record, and I'll just summarize here and now that they fall into two broad categories. First, while we believe it is possible and appropriate to reveal information about the number of targets of surveillance, counting the number of persons or of U.S. persons whose communications are actually collected, even if they're not the targets, is operationally very difficult, at least without an extraordinary investment of resources, and maybe not even then. For example, it's often not possible to determine whether a person who receives an email is a U.S. person. The email address says nothing about the citizenship or nationality of that person. And even in cases where we would be able to get the information that would allow us to make the determination of whether someone is a U.S. person, doing the research and collecting that information would perversely require a greater invasion of that person's privacy than would otherwise occur. It's for these reasons that the Inspectors General of the National Security Agency and of the intelligence community have stated in letters to the Congress that this kind of information simply cannot be reasonably obtained. Second, we have significant concerns with allowing individual companies to report information about the number of orders to produce data that they receive under particular provisions of the law. Providing that information in that level of detail could provide our adversaries a detailed roadmap of which providers and which platforms to avoid in order to escape surveillance. We believe that the reporting we've already agreed to provides the right balance between transparency and national security. Mr. Chairman, I want to emphasize our intention to work with the Congress and with this committee to ensure the maximum possible transparency about our intelligence activities that's consistent with national security. The President is committed to this. The Director of National Intelligence is committed to this. The Attorney General is committed to this. General Alexander is committed to this. We're open to considering any proposals so long as they do not compromise our ability to collect the information we need to protect this nation and our allies. And we look forward to working with you in this regard. Thank you.
Thank you. Mr. Litt, Mr. Wigman.
Thank you, Mr. Chairman. Thank you for having me here today. I don't want to replicate what Bob Litt has just explained, so I don't want to waste the committee's time, but we at the Department of Justice very much agree with what Bob has just explained. We very much support the transparency efforts that the intelligence community is engaged in now. We also, as Bob said, share the goals of the bill that you have prepared in terms of increasing transparency, but we have some technical concerns about how those proposals can be implemented that we're happy to discuss today. I guess I would just say a couple of other things. One is that I think this is an area where the details very much matter. We are very much support transparency, but we want to do so in a way that's consistent with our national security needs. You've seen a number of documents declassified over the last several months, and I'm sure from the outside it looks very slow and ad hoc, as you said earlier. That's because these documents involve a lot of detailed classified information, and it takes a lot of time to go through the documents and determine what can safely be revealed and what cannot. And there are a lot of equities of different components of the intelligence community that have a stake in the information in play. So our transparency efforts are a work in progress. We continue to work on them as we go forward, but we're trying to do so in a careful and deliberate way. But I don't doubt that to the outsider it looks as if it's slow and ad hoc, but that's because we're trying to protect national security while also promoting transparency goals. So with that, I guess I'll just, the other thing I guess I would say, in addition, though, is to contrast the U.S. response to these disclosures to those of some foreign governments. We have, in response to these unauthorized disclosures, tried to be more transparent, and that's not always been the case with other governments that have experienced this, either in the past or more recently. So I do think we're working in good faith to try to be more open about our intelligence collection activities, and we're happy to work with the committee to continue to promote that goal. That's all I have.
Well, thank you, Mr. Wigman, and thank you both. As I said, that you submitted joint testimony, and of course that will be part of the record. So I appreciate your not taking every minute of your time here. And I will say about the disclosures that I've said that these have been, I think, in good faith. It's just that there's nothing in the law about them. So there's nothing permanent about what you're doing. And what we're trying to do is create a framework where people have a little bit more confidence and or understanding, or can decide for themselves whether they should have confidence. Mr. Litt, you indicated that ODNI may lack the technical ability to estimate the number of U.S. citizens and permanent residents whose information has been collected under the different surveillance authorities. I find this kind of troubling. Here's why. We give the intelligence community broad legal power to conduct surveillance precisely because that surveillance is supposed to be targeted at foreign adversaries and not at Americans. Many of the broadest laws we've written, like Section 702 of FISA, explicitly say that you can only use this law only to target foreign people. You cannot use it to target U.S. persons. Mr. Litt, isn't it a bad thing that NSA doesn't even have a rough sense of how many Americans have had their information collected under a law, Section 702, that explicitly prohibits targeting Americans?
So I have to preface everything here by emphasizing that I'm a lawyer, not an engineer or a computer scientist, and so everything I say here gets filtered through that PRISM.
Well,
But
if you're an engineer or a computer scientist, we'd have you working on something else.
But I think it's important to differentiate here between the concept of who is targeted for collection and whose collections are incidentally collected. NSA, because of the legal requirement, for example, under Section 702, that NSA only target non-U.S. persons, NSA does the research necessary when they have a target to determine whether that person is or is not a U.S. person. They need to be able to make that determination. That's a very, very different process from saying we're going to look at all of the communications that are collected and we're going to evaluate every single party to every one of those communications to determine whether or not that's a U.S. person. So they do have the ability to try to make the determination as to whether somebody is or is not a U.S. person for the purpose of targeting that person. But that's a different proposition.
Okay, well, I think an estimate, though, could be made through statistical sampling, a method that has been used in comparable circumstances before the FISA court. I'd like to add to the record two pieces of testimony that to me suggest that the NSA could be able to estimate how many Americans have had their information collected under foreign intelligence authorities. The first is from General Alexander. He testified in September that the NSA employs over 1,000 mathematicians, more than any other employer in the United States, more than every university in Minnesota, more than MIT or Caltech. The second piece of testimony is from Ed Felton, a Princeton professor and the former technologist for the Federal Trade Commission. He said that, quote, yes, the government has the ability to give a rough estimate of the number of American citizens and permanent residents whose metadata and content has been collected. But let's move on to the disclosure by the companies. Mr. Litt, in your testimony, you warned that, quote, from your testimony, more detailed company-by-company disclosure threatens harm to national security by providing a roadmap for our adversaries on the government's surveillance capabilities. This concern makes sense, but I have difficulty reconciling your testimony with the government's actions with respect to major companies like Google. The government lets Google publish the number of national security letters it receives each year and the number of users affected. And 2 months ago, Michael Hayden, the former director of NSA and of CIA, gave a speech in which he said, quote, Gmail is the preferred internet service provider of terrorists worldwide. That's a verbatim quote, according to the Washington Post. Mr. Litt, it seems to me that if the former head of the CIA and the NSA doesn't think it's a problem to let everyone know that terrorists just love Gmail, then why do you think that a company-by-company disclosure threatens national security? He evidently doesn't.
A couple of thoughts on that. To my knowledge, General Hayden didn't talk to us before making those statements. I don't know that we would have authorized that statement to be made. I just don't know what was done there. The point is that if we allow the companies on an annual basis to publish these statistics, it's going to simply provide additional information out there as new companies come online and pop up. You may have a company that, for example, for a period of years shows no orders and then all of a sudden starts showing orders, and that conveys a message that says, oh, we've got the capability to collect this now. It's the more detail we provide out there and the more we break this down by authorities and companies, the more easy it becomes for our adversaries to know where to talk and where not to talk. What we have agreed to allow the companies to do is to report the aggregate number of times in which they provide information about their customers to the government. And that, it seems to me, is an adequate way of providing the public the information they need to know about the minuscule proportion of times in which that actually happens. And breaking it down further, in our view, crosses the line of the appropriate balance between transparency and national security.
We're going to have testimony from some privacy people and from Google talk about that aggregation. I don't think that aggregation is all that helpful, because you really are not giving people an idea of how much is. I mean, you're mixing apples and oranges. So you're having how many wiretaps there are, mobsters with. I mean, to me, it doesn't create the kind of transparency that creates the kind of knowledge the American people. I have some time. Gives the American people a way to judge the program. Let me ask Mr. Wigman something. I'm the chairman. I guess I can go over my own time, but I got 9 seconds here, and I'll try to answer a question. Or ask one. Mr. Wigman, I understand that you think that my bill would require too much detail in government reporter. I'm going to weigh that feedback very carefully. But I do want to point out that when I drafted the government reporting requirements in a bill, I modeled them after the wiretap report that the Department of Justice releases every year. If you look at last year's report, it breaks down the number of wiretaps, not just nationally, but by specific jurisdiction, and then breaks down those numbers by the nature of the wiretap, a mobile phone, a home phone, a business phone. Last year's wiretap report shows that federal prosecutors in Manhattan secured wiretap orders for mobile phones 48 times in 2012, while their colleagues in Brooklyn only did this 5 times in the same period. The wiretap report contains a wealth of information, yet nobody's arguing that criminals in Manhattan are reading the wiretap report and fleeing to Brooklyn because, you know, they're less likely to get their phone tapped there. My bill wouldn't even require anything near this level of reporting. It would require the government to report national statistics, and any time the number of Americans affected was lower than 500, the report would just say fewer than 500. Mr. Wigman, why would the reporting requirements in my bill raise national security concerns if the far more detailed reporting requirements in DOJ's wiretap reports don't raise public safety concerns?
So that's a good question. The regular wiretaps under the Wiretap Act don't involve classified techniques. So there are platforms that we use in the intelligence context that it's unknown to the outsiders or anyone outside the executive branch as to whether we can collect on a particular communications technology. So the difference.
I'm not having you.
What's that?
The disclosure wouldn't be talking about a technology other than it's on the internet or phone.
Right.
You know those technologies.
So we think that our adversaries can surmise, let's say, for example, in year one, we know that there's a company that has a particular number of surveillance requests, and that number is published. They then introduce a new capability, a new service that they provide, and then all of a sudden that number goes up dramatically in the following year. That's something that our adversaries could glean information from that and surmise as to whether we have the capability to collect on a new technology. So that's the type of thing that I'm talking about that's different than in the wiretap context where everyone knows that a basic phone tap is something that you can do. So that's the difference there. I'd also like to address briefly your last question to Mr. Litt about NSLs. The reason why NSLs are different than other collection methods, that's just collecting business records. It's not an interception capability. It's not you're not intercepting communications in real time. You're just collecting business records that the companies have. And so that's a distinction there, that we don't have the same concerns about revealing those numbers in aggregate that we would with intercept capabilities.
Well, thank you. I thank the ranking member for his indulgence. I've gone way over my time. I thank you too, but please continue.
Well, thank you. Well, that's been useful questions and some of the same questions that I had as well. But Mr. Litt, if you could kind of drill down a bit in terms of increased manpower and what it would take to actually make some determination of the percentage of individuals who are U.S. citizens who are surveilled. What would that look like without revealing more than you need to reveal here? What would that take to actually go through and determine what percentage?
So I can offer actually an example in that regard. The chairman made reference to the FISA court opinion that we've released from 2011, which involved a compliance violation under the collection under Section 702. And in connection with that, NSA did do a statistical sample to try to determine how many wholly domestic communications may have been intercepted through one portion of this collection. And they did a statistical sample where they reviewed, I think, approximately 50,000 communications, which was a very small percentage of that. My understanding is that it took a number of NSA analysts about 2 months to do that. And that even in that regard, there were a number of instances where they simply couldn't come up with the necessary information, that the actual information was in ended up with numbers in a wide range based on a lot of assumptions. And the last point I want to make on that is that that was actually an easier task than the one that's being asked here, because they were looking for a wholly domestic communications, which means that any time they found a communication where there was one non-U.S. person, they could immediately throw it out and not look any further. So they never did actually go through and look at every single party to every single communication to determine whether or not it was a U.S. person. So I think that that example gives a sense of the resource intensiveness that would be required and the difficulty, even if you apply all those resources, in coming up with reliable numbers at the end of the process.
Right. So you maintain that it would probably bleed a lot of resources away from the main task just to comply with this provision.
Yeah, I think those 1,000 mathematicians have other things that they can be doing in protecting the nation that rather than trying to go through and count U.S. persons.
Now, in your testimony, you mentioned that it may have a greater impact on privacy to actually have to drill down and determine who is a U.S. person and who is not. What level of detail do you typically have to have? You have to run, I guess, search what other communications have come to this person or whatever else, and those are the things that, can you kind of explain what you mean by saying that you impact more on people's privacy by drilling down and complying with this law than are currently out there?
Yeah, that's exactly right. NSA's mission is to collect foreign intelligence. They're looking for the foreign side of thing, and it's not what they ordinarily do to go out and try to find U.S. persons. And so, if you impose upon them some sort of obligation to identify U.S. persons, they're going to take an email address that may be joe@hotmail.com. And they're going to have to dig down and say, what else can we find out about joe@hotmail.com? And that's going to require learning more about that person than NSA otherwise would learn.
When, Mr. Wigman, we allowed the companies out there, Google and others, to reveal more than they were able to reveal before, Google has procedures that they follow. What other companies have taken advantage of the opportunity they have to reveal more information about what is surveilled and what is not? Are they all, is it universal, all of them are taking advantage of this, or some of them, or what?
I'd have to get back to you and give you the list of companies. I believe Microsoft has issued a transparency report about with certain data. Facebook, I believe. I'd have to get you the complete list. I don't want to give you the wrong list of companies here, but I could give you the information about which ones have taken advantage of the government's offer thus far.
All right. I'm sure we'll learn more in the next panel, but is it your understanding that all of them, how universal is the request for the ability to give broader information or more information about what is being surveilled and what is being collected and whatever else?
I think it's fair to say that a lot of the major internet service providers do want to provide more information about their how their users are affected by government surveillance. A number of them, in the initial stages of this, in the wake of the initial Snowden unauthorized disclosures, came to us, and so we work with them on the proposal that Bob described, which was that we would release the aggregate number of law enforcement plus national security demands in the aggregate for those companies. I think they found that useful at the time because they put out press statements and so forth saying, identifying those numbers and showing that that was a tiny fraction. I think in most cases less than 1/10,000th or 1/100,000th of their user base was affected by not only the national security demands, but also the law enforcement demands together. So whether you slice out the national security or whether you include the law enforcement, it's a tiny, tiny fraction of their total user accounts, and that's what they wanted to be able to show, as Senator Franken was saying, to debunk the idea that we're engaged in some kind of dragnet surveillance whereby we're getting access to all of their users. And in fact, the opposite is true, that it's a tiny, tiny number, and they were able to do that with the disclosures that we authorized at that time.
Thank you. Mr. Litt, getting back to what we were talking about before, in order to comply with the provisions of this legislation, would you sometimes require more of the companies in terms of trying to follow down and drill down on how many U.S. persons were affected here? Might there be additional concerns from the private providers that were, I don't know, might they be more uncomfortable with additional requests to try to determine, and we already have minimization procedures that apply in order to exclude U.S. persons, but this would seem to be a lot more drilling down, as you mentioned before. What concerns do others have about this, and should they be concerned about more intrusiveness on the part of the government to determine who is a U.S. person and who is not, just for the purpose of complying with the Act?
Well, I do think that people should be concerned about the greater intrusiveness. I'm not sure technically whether it would require any more of the companies or not. I think that more likely NSA would simply rely on its own internal resources rather than, because they'd need some additional authority to go back to the companies to get subscriber information or whatever. So I'm not sure that it would impose an additional burden on the companies, which does not in any way mitigate the intrusion on the individual.
But you don't anticipate having to go back to the companies and say, we need additional information in order to determine or to comply with the law?
I guess I wouldn't say that I don't anticipate it, but I'm not sure that it would happen, or that frankly there would be a way we could do it legally to get that information from the companies.
Thank you, Mr. Chairman.
Thank you, and I will say that we are going to have testimony from Google, and they have signed on to this, as have those companies, so we'll hear from them. Senator Blumenthal.
Thank you, Mr. Chairman. Thank you for your leadership on this bill. Thank you to our ranking member and to Senator Heller. I'm a co-sponsor of this measure and really want to express my gratitude to you, Senator Franken, for spearheading this effort. But of course, it really embodies the general truth that what you don't know can hurt you. And what the American people don't know about much of what you do, and it is important, indeed essential work to our national security, can create misinformation and deception and undermine the trust and credibility in the entire program of surveillance and intelligence vital to national security. So what the American people don't know can hurt them if it becomes a source of mistrust and loss of credibility here and around the world. So I think that this bill is very important, albeit only a first step, and I've proposed other measures such as a constitutional advocate that I think fits with the concept of this bill in terms of preserving an adversarial and accountability measure, as well as greater transparency and accountability in other ways. I would like to focus on the technical issues that you've raised. Don't these pale compared to the importance of the objective, and aren't they surmountable with relatively few resources if we define narrowly what those technical problems are?
Well, taking, I mean, I guess I would say no and no. Taking your second point first, the judgment of people who have looked at this, not only people within NSA, but as I said, 2 inspectors general who've also looked at it, is that this is not surmountable with a relatively modest application of resources, that it would be very resource intensive, and, as I said, particularly with respect to the U.S. persons, very require additional intrusions on privacies. Our judgment is that this is not the best way to try to strike the balance between privacy and national security. I understand that the view that there's important information out there, but one of the necessities of conducting intelligence operations is that not all the information that might be of use to the public is going to come out in the public. So I think that our view is that the steps that we've taken are appropriate ones, and we're prepared to work with the committee and the Congress on additional steps that might be taken. But
I don't understand, and forgive me for interrupting, sure, but my time is limited. I don't understand what resource intent, that's a code word. It's a term of art, maybe, that's used to say it looks pretty difficult to do. It looks like it's going to cost a lot. How resource intensive really is it to accomplish these purposes?
I don't know that we've done an actual cost estimate. The only yardstick I can give you is what was required to do the smaller and easier task that was done in connection with the FISA court opinion that required, I believe, a half dozen analysts 2 months to do, and still come up with an estimate that had wide ranges in it. And as I said, that was an easier task.
Maybe you can give us some idea of what those ranges are.
If you give me a second.
This will not come out of the senator's time.
Yeah, it's a long opinion, and it's going to take me a second to find the right place. I'm sorry, I should have marked this in advance. So as I said, the issue was to determine what were wholly domestic communications, which I said is a different task. And as a result of this review, they determined that there were between 996, essentially between 1,000 and 5,000 communications that met that test. So you have a range, a five-fold range there. And there are other estimates in here, for example, that say, well, it wouldn't be any greater than this number. But they're all based on assumptions and estimates. And I don't know that there's any comfort that we could accomplish this with any degree of reliability.
But you've given me a number for the communications, but not a number for the dollars, to put it perhaps oversimplistically. Yeah, how do you measure resource intensive?
I mean, you have to look at the number of people who would be required and the amount of time that would be required.
Can you give us some idea of what they would be?
As I said, the only metric that I have is what was required to get this number, and my understanding is that was, I believe, 6 analysts for a 2-month period. You'd have to multiply that across a much larger sample, a much more difficult task, and additional FISA authorities. So you're talking. Some number of man years that would be required to do this.
Thank you. Let me just move on in the interest of perhaps anticipating the testimony we're going to receive from the next panel. I don't know whether you've had a chance to review that testimony, but for example, a lot of it concerns the impact on communications internationally. And I wonder if you could comment in particular on the testimony, very compelling testimony from Mr. Salgado about the need for transparency to enable the trust and credibility that is important for communications worldwide.
So I haven't had a chance to review the other testimony. I'm generally familiar with the company's position. I think we have a lot of sympathy for their position. the unauthorized disclosures that have come out here have put them in a difficult position. It's one of the many things that we regret about these disclosures. Having said that, as Brad mentioned earlier, we're prepared to authorize the companies to release the total number of orders they get to disclose customer information and the total number of accounts affected by those orders. That's going to be a minuscule number. As Brad said, it's something like, it's a fraction of 1%, and that covers all authorities. And it seems to me that that minuscule number is sufficient to meet the company's needs, and it really doesn't advance things anyway when they're allowed to disclose that 0.0001% of their customer accounts are affected by orders to provide information to the government. It doesn't really advance their needs to say, well, 0.00001% of those were pursuant to this authority and 0.00003% were pursuant to that authority. The relevant statistic is that any customer of Google or of any other company, there's only an infinitesimal likelihood that that person's information is ever going to be asked for by the government.
Thank you. My time has expired. Thank you very much. Thanks, Mr. Chairman.
Thank you, Senator Blumenthal, and I am a co-sponsor of your constitutional advocate.
Right. Thank you.
Bill, Senator Lee.
Thank you, Mr. Chairman. Thanks to you for being here with us today. Much of the testimony that we've received today highlights the consequences of unchecked government intrusion into the private lives of citizens and their interactions with private businesses. Senator Franken's bill would take important steps to increase the transparency of government requests for information, and I very much applaud those efforts. In fact, Senator Leahy and I have incorporated the vast majority of Senator Franken's provisions into our bill, S 1215, the FISA Accountability, Privacy and Protection Act, which makes broader reforms to the privacy protections within the FISA program. Our bill would tighten statutory authorities governing surveillance, would increase oversight and accountability, and would ensure that Americans' constitutional rights under the Fourth Amendment are protected. The reporting provisions in these bills guarantee that we have an accurate understanding of the scope of these information collection activities and allow businesses to regain the trust of the public through the reasonable disclosure of their interactions with government agencies as they provide information. It's time we started requiring a little more sunlight in this fairly shadowy space. Mr. Litt, in your written testimony, you expressed support for the majority of the disclosure requirements in this bill. I was wondering, is your support a direct result of formerly covert collection programs having become public, or do you think that nationwide aggregate disclosures are inherently beneficial and should be sought out?
I think the answer to that is that aggregate disclosures are a good thing provided they don't compromise our ability to collect important information. I think in the situation where we're in right now, whatever the appropriate result might have been 6 months ago, in the situation we're in right now where the Director of National Intelligence has already declassified the fact of certain programs and how they operate, that it's entirely appropriate to have aggregate disclosures of these activities going forward. For other important intelligence activities, I'm not sure that we'd reach the same balance, but to the extent that we're talking about these particular disclosures, we believe that they do strike the right balance now. If I could just, for one thing, I know this is perhaps not considered a discreet thing to do. I do want to take issue with your suggestion that we're talking about unchecked intrusions into privacy of Americans, because in fact they're very checked. We operate within the laws authorized by Congress. We operate with extensive oversight from all three branches of government, and they're highly regulated and highly checked. Whether or not they're appropriate or not, I think, is a valid question. But nobody should be under the illusion that we're operating without any checks on what we do.
And that is a fair point, and I understand your position there. One of the concerns is always, of course, that what might well be handled by responsible people today, tomorrow might not be. We don't know whether that might happen a week from now, or a year from now, or 10 years from now, but in a sense, we've seen this movie before, and we know how it ends. If you give too much power to the government with regard to domestic surveillance, eventually it will be abused, and we need to put in place whatever procedures might be necessary. If I understand your answer to my question correctly, part of what you're saying is that prior to the declassification that occurred recently, this might have run afoul of, this might have triggered your concerns. This kind of legislation might have triggered your concerns in the sense that it might have compromised ongoing activities. But since those have now been declassified, there's no reason not to do this. Am I understanding you correctly?
Yes, I think that's right.
Okay. Okay. Thank you, sir, and thank you, Mr. Chairman.
Thank you, Senator. I want to thank you, gentlemen, for not just for your testimony, but for your service. You made a good point there about there are checks to what you do, and this is part of it. And you made a comment that there are checks on what you do, but that doesn't mean what you do is always appropriate, and that's what we're trying to get to here. You have made some disclosures that I think have been in good faith, but they aren't permanent. They aren't part of the law. And so that's what we're discussing here. And again, I want to thank both of you for your testimony, and now I want to call our third panel. So thank you.
Thank you, Mr. Chairman.
Both gentlemen.
Thank you.
Kevin Bankston is Senior Counsel and Director of the Free Expression Project at the Center for Democracy and Technology. Mr. Bankston is a longtime advocate and litigator on privacy, civil liberties, and Internet policy matters. Mr. Bankston and the Center for Democracy and Technology organized and led the coalition of companies and civil liberties groups that call for greater transparency, and that now is advocating the passage of this bill. Paul Rosenzweig is the founder of Red Branch Consulting, a national security consulting company, and a senior advisor to the Chertoff Group. From 2005 to 2009, he served as Deputy Assistant Secretary for Policy in the Department of Homeland Security. He also teaches at George Washington University Law School. Richard Salgado is Google's Director for Information Security and Law Enforcement Matters. He served as a federal prosecutor in the Computer Crime and Intellectual Property section of the Department of Justice, where he specialized in technology-related privacy crimes. He has taught at Stanford Law School, Georgetown University Law Center, and George Mason University Law School. Thank you all for joining us. Your complete written testimony will be made part of the record. You each have 5 minutes, about 5 minutes, for any opening remarks that you would like to make. Mr. Bankston, please go ahead.
Chairman Franken, Ranking Member Flake, and the members of the subcommittee, thank you for the opportunity to testify on behalf of the Center for Democracy and Technology, a nonprofit public interest organization dedicated to keeping the Internet open, innovative, and free. I and the broad coalition of Internet companies and advocates that CDT brought together this summer to press for greater surveillance transparency are grateful to Chairman Franken and Senator Heller for introducing the Surveillance Transparency Act, a bill that would allow companies and require the government to publish basic statistics about how the government is using its national security surveillance authorities. Particularly in the wake of recent revelations about the NSA's surveillance programs, we believe this level of transparency about what companies do and don't do in response to government demands is critically important for 3 reasons. First, the American people and policymakers have a clear right and need to know this information so that they may have a more informed public debate about the appropriateness of the government's use of its authorities and to better ensure that those authorities are not misused or abused. Second, the company First Amendment right to tell us this information, and the government's attempt to gag them from sharing even this most basic data, or even to admit that they have received foreign intelligence demands at all, is clearly unconstitutional. Indeed, you'll see this prior restraint at work today in the room, even though everyone in this room knows and understands that Google has received Foreign Intelligence Surveillance Act process. Google's representative is the one person in the room who cannot admit it. Third, greater transparency is urgently necessary to restore the international community's trust in the U.S. government and in our U.S. internet industry, which is projected to lose tens, if not hundreds of billions of dollars in the face of widespread concern from foreign governments and international users. We must take this opportunity to demonstrate that our surveillance practices are necessary and proportionate and respectful of constitutional and human rights. And if the numbers show otherwise, we must take this opportunity to reform our surveillance laws to better protect our rights as well as our national security. Speaking of national security, there are two basic arguments why publishing these numbers would threaten it, but neither is persuasive. First, there's concern that such reporting will reveal which services have not been targeted by the U.S. government, such that our enemies will seek them out. However, it has always been the case that companies that haven't yet received secret national security demands can say that they have not received secret national security demands, as was most recently demonstrated just last week when Apple revealed that it has never received an order under Section 215 of the Patriot Act. The second argument is that reporting will reveal which services have been targeted, such that our enemies will avoid them. However, this concern rings somewhat hollow when top intelligence officials such as current NSA Director Keith Alexander have repeatedly and publicly announced the names of various services such as Google, Facebook, Twitter, and Yahoo that they believe terrorists are using. Senator Franken also mentioned a comment by former NSA Director Michael Hayden. Put simply, and as these generals recognize, saying that someone on a service is being surveilled is very different from identifying who on that service is being surveilled, and only the latter is dangerous to national security. Therefore, the less transparent alternatives to the bill that the government has suggested are unnecessary to protect national security. More than that, they would actually be worse than the current transparency status quo. On the government reporting side, the DNI has announced he will voluntarily publish new statistics reflecting how many people have been, quote, targeted, unquote, under various surveillance authorities. But such limited reporting would actually be misleading. For example, the DNI's reporting for 2012 would only have indicated that around 300 people had their telephony metadata targeted under Section 215 of the Patriot Act, yet we now know that the government has used Section 215 to obtain the phone records of every single person in the country. Such falsely reassuring reporting would do more harm than good. On the company reporting side, the government advocates for a lot of what I'll call fuzzing and lumping. They want to lump together into a single number all the different foreign intelligence authorities, as well as all state, local, and federal law enforcement requests, and then fuzz that number up by putting it into a range of 1,000. That kind of fuzzing and lumping would be a step back for transparency, obscuring more than it reveals, especially considering that companies are already engaged in detailed reporting about the law enforcement process they receive, and in some cases have also been allowed to publish separate rounded numbers about the national security letters they receive. No one's ever suggested that either that reporting or the detailed reporting that the government has done for decades about its law enforcement wiretapping has ever disrupted an investigation. Neither would the reporting required and allowed for under this bill or that provided by the transparency provisions of the USA Freedom Act, another bill that CDT strongly supports. Greater transparency is no replacement for substantive reform of our surveillance laws, but it can serve as a key stepping stone toward that broader reform by allowing the public and policymakers to better understand how the government is using its powers. So I thank you for your consideration, and I look forward to your questions.
Thank you, Mr. Banks and Mr. Rosenzweig.
Senator Franken, Senator Flake, members of the subcommittee, I thank you very much for the invitation to appear today. It is always an honor to be asked to provide one's views to the Senate of the United States, and I thank you for affording me that opportunity. I should begin by saying that as a current holder of a top-secret clearance for some of the work I continue to do for DHS, I have limited what I have read to what has been lawfully declassified by the DNI, as have most of the people in my position, which somewhat constrains how I can speak to the issues today. That having been said, I would make four basic points. The first is that transparency is a good thing, but unlimited transparency cannot be our end goal. secrecy itself has its virtues in any number of circumstances. One can think of everything ranging from the attorney-client privilege to the identity of an undercover officer in a gang in Los Angeles to any number of reasons why governments legitimately keep secrets that are subject to oversight in a classified manner, either through the oversight of the executive branch or the legislative branch, or in some cases the judicial branch. Thus, while I fully support the overarching sentiment that underlies much of the bill that is before you, that is the idea that we can and should seek to increase transparency with respect to the NSA surveillance programs, I think that we have to do so in a calibrated way, one that takes into account what the end goal of transparency in this circumstance is. Now, I would submit that the end goal here is greater oversight, greater audit, greater assurance that the NSA and other intelligence community activities are acting in conformance with the laws as we've set them out, and not in ways that are in violation of those laws. So, to my mind, the right answer to many of the questions that you're asking is, how will the transparency that you're advocating advance that goal? With that in mind, my second point is that I think that the proper reflection on what we should be learning more about with respect to the NSA surveillance is to require a lot of disclosure of aggregate information, a lot of disclosure to, with respect to existing programs, but that we should take very seriously the protestations of government officials who are, frankly, in a better position to know than I am, at least, given what little I know about the classified nature of these programs, that further disclosures will disclose sources, methods, capabilities that have not yet publicly been disclosed. Indeed, my single greatest constructive criticism that I would offer with respect to the bill before you is the idea that the disclosure requirements are keyed to statutory programs themselves and like Section 215 or Section 702, and seems to operate from the unstated assumption that we have already learned all of the classified programs that are operating under those statutes. If that's the case, then the transparency that is key to those sections is to be welcomed, indeed. I suspect, without knowing, that there are other programs involved, other covert programs that have not yet been disclosed, either lawfully or unlawfully, and it is at least plausible to me that further disclosures of particularized numbers would lead to the disclosure of programs that have not yet made it into the public record. If that were the case, I would think that that would be an unfortunate result. My third point would simply be that the most effective reforms, I think, are not just enhanced transparency for the American public, but more structural reforms, things that you can do that aren't part of this bill, that are part of, I think, what Congress can do, things like making the NSA Inspector General a presidential appointment, expanding the jurisdiction of the Privacy and Civil Liberties Oversight Board. Those sorts of things don't sound as sexy as greater transparency, but I tend to think that in the end they will actually prove more effective than even the most detailed disclosure of individuated numbers within various programs. With that, I will conclude, and I look forward to your questions.
Thank you, Mr. Rosenzweig. Mr. Salgado.
Chairman Franken, Ranking Member Flake. Thank you. Chairman Franken, Ranking Member Flake, Senator Blumenthal, and Senator Lee. I thank you for the opportunity to appear before you this morning to talk about the Surveillance Transparency Act of 2013. My name is Richard Salgado. I am the Director for Law Enforcement and Information Security at Google. In that capacity, I oversee the company's response to government requests for user information under various authorities. I'm also responsible for working with teams across Google to protect the security of our networks and our user data. Mr. Chairman, we commend you for introducing the Surveillance Transparency Act of 2013. Simply stated, we believe that service providers should be able to disclose basic statistics about national security demands that we may receive. The revelations about the U.S. government's and other governments' surveillance practices over the past few months have sparked a serious debate about the laws governing surveillance of private communications by the intelligence community. Google recognizes the very real threats that the U.S. and other countries face today, and of course governments have a duty to protect their citizens. But the current lack of transparency about the nature of government surveillance in democratic countries undermines the freedom and the trust most citizens cherish. It also has a negative impact on our economic growth and security, and on the promise of an internet as a platform for openness and free expression. In the wake of the press reports about the so-called PRISM program, governments around the world have been considering proposals that would limit the free flow of information. This could have severe unintended consequences, such as a reduction in data security, increased cost, decreased competitiveness, and harms to consumers. Proposals like data localization pose a significant threat to the free and open internet. If they're adopted, then what we will face is the effective creation of a splinternet, broken up into smaller national, regional pieces with barriers around it to replace the global internet that we know today. Enacting the Surveillance Transparency Act would allow the U.S. to take a first step towards rebuilding the trust that's necessary. Transparency and national security are not mutually exclusive. Since 2010, we've published a transparency report where we share information about the law enforcement requests for user data we receive from governments around the world. Earlier this year, after some discussions with the Department of Justice, we began providing more information about the volume and scope of national security letters that we receive, although in broad ranges. There has been no intimation from the Department of Justice that publishing statistics concerning NSLs has damaged national security. We approached the DOJ about expanding our reporting to include aggregated statistics about FISA requests that we may receive. We were disappointed that the Justice Department refused. In June, we filed a motion for declaratory judgment before the Foreign Intelligence Surveillance Court, asserting a First Amendment right to publish this type of information. The DOJ repeated that it would allow companies to add the number of domestic law enforcement and national security requests together and report the sum as falling within some broad range. But this would be a significant step backward for Google's users and the broader public. Rather than promote transparency, this proposal would actually obscure important information about the volume and type of all government demands that Google may receive, not just national security demands. As I mentioned, Google already discloses aggregate statistics about domestic law enforcement demands and have done so since 2010. Publishing future reports where we could only release this type of information in ranges rather than actual numbers and type would provide less transparency than we have now. In addition, there would be no discernible benefit for transparency around national security demands that we may receive. Indeed, Google would continue to be prohibited from even acknowledging their receipt, which would only invite continued speculation about the import of the range that we are able to report. We would also lose the benefit of providing information specifically about national security letters that we currently enjoy. In short, the DOJ proposal would not provide the type of transparency that is reflected in the Transparency Surveillance Act of 2013. Transparency is critical in informing the public debate on these issues, but it's only one step among many that are needed. 2 weeks ago, Google, along with AOL, Apple, Facebook, LinkedIn, Microsoft, and Yahoo, voiced support for broader FISA reform that would include substantial enhancements to privacy protections and appropriate oversight and accountability mechanisms. We strongly believe that governments throughout the world must revisit laws and practices governing state surveillance of individuals and access to private communications. This activity must be rule-bound, narrowly tailored, transparent, and subject to oversight. We look forward to working with the Congress on the Surveillance Transparency Act of 2013 and other reform measures. Thank you for your time and consideration.
Thank you, gentlemen, for your testimony. Mr. Bankson and Mr. Salgado, you heard witnesses from ODNI and DOJ say that it would be very difficult for the government to provide an estimate of the number of U.S. Persons caught up in surveillance. Do you agree with them?
I'd prefer to talk about what the NSA should be able to do rather than getting into a debate over what they technically could do, although I have some opinions about that as well. The authorities we're discussing today are foreign intelligence authorities. They are predominantly intended to and are sometimes limited to acquiring the communications of foreign persons or persons outside of the United States and have special protections for U.S. persons. Therefore, knowing how many U.S. persons have been surveilled, have been swept up intentionally or unintentionally under these powers is critical to understanding whether they're being used correctly, proportionately, and in line with constitutional and statutory limits. And the fact that the NSA is claiming that it does not have the ability to provide even a rough estimate as to how many U.S. persons have been swept up in this in their surveillance is quite frankly shocking, and I think points to perhaps a need to recalibrate what we are authorizing them to do if they cannot even judge how their activities are impacting the American people. More importantly, I'm also disappointed to hear the implication that the NSA has more important things to do than to ensure that it is not inappropriately impacting the privacy of U.S. persons. That should be a core priority of the NSA, one that it can and should dedicate a reasonable amount of resources to. And we think that with a reasonable amount of resources, it can, as demonstrated in the FISA court case of 2011, take measures to make reasonable estimates about how their authorities are impacting.
Indeed, in the Bates FISA court decision 2011, NSA had been violating its authority, right? And they were able to discover that partly by doing the kind of estimation that they did.
Indeed, and if such estimates had been required, if those had been required earlier, we would have found out 3 years earlier that Americans were unconstitutionally being surveilled and presumably would have put a stop to it.
Mr. Salgado.
I think it certainly makes sense to explore all the various ways that we can increase transparency around these programs, whose data is being collected and what data. We want to be able to do that, of course, in a way that's a practical, reliable way. So I think it makes good sense to explore the different ways that that kind of an obligation could be satisfied by the government, and to take into account the costs that may be necessary to incur. But certainly the value of that sort of detail is significant.
Thank you. Mr. Bankson, you organize an impressive coalition of dozens of technology companies and civil society groups, all calling for greater transparency and endorsing my bill specifically. It's a broad coalition of the nation's leading technology and internet companies, including Google and Apple and Microsoft and Facebook, as well as many of the leading civil liberties books. But Mr. Salgado, could you just speak to why Google and Apple and Microsoft and Facebook are companies that normally compete with each other are working together on this, and what this means in terms of your business?
Yeah, thank you, Chairman. The disclosures that we've seen coming out in June and then since then have really the great potential for doing serious damage to the competitiveness of these American companies. There's a potential for great damage to the Internet as a whole, but certainly what I think these companies and Google recognizes is that the trust that's threatened is essential to these businesses. It's very important that the users of our services understand that we're stewards of their data, we hold it responsibly, we treat it with respect, and that there's not any sort of confusion around the rules where we may be compelled to disclose the data to the government. And when there are rules around that it's clear what they are, and the interaction between the government and Google and the other companies as well. This is essential to make sure that the users have confidence in their ability to place and trust their data with us. The impact of the disclosures in June are manifest. We can see as an academic matter, or rather as an anecdotal matter, that customers who may be considering using the rich services available in the cloud are nervous to do so now as a result of those disclosures. This means that companies, some abroad and some in the United States, may not be taking advantages of the efficiencies and security benefits and all the other advantages of the cloud as a result of this. It's a terrible result and one that we need to address. Transparency, among other steps, would help restore the confidence in the cloud and American companies.
Thank you. The ranking member.
Thank you. Appreciate the testimony. Mr. Salgado, You heard the testimony previously in my question as to whether or not some of the companies would be concerned, would share the concern that there'd be increased privacy concerns were this additional information to be gathered. Tell me why that doesn't make sense, or tell me why you disagree.
Senator, I assume you're referring to the U.S. persons step within the government disclosure portion. I don't think, I think I share Mr. Litt's view that it's unlikely that this would result in any more disclosures by companies to be able to make this the evaluation that would be required of the government.
So they have the data, they could simply drill down on their own data without asking you for additional information?
That's what I would anticipate, sir.
And revealing more information about drilling down on U.S. persons doesn't concern you as a company to have that additional information out there as required in this legislation?
I think that as we look at the methods by which the intelligence community may address the U.S. persons estimation, it makes sense to look at that. How do you minimize those additional steps, and do they in fact require intrusions where there weren't any before, with absent that obligation?
Mr. Bankston, do you have any thoughts on that? Overall, the general privacy concerns that they raise, that there are additional concerns about privacy that would be raised by drilling down on this information?
I think it's important to note that to some extent privacy is invaded and has been invaded when the government collects the data itself. And to say that we cannot make a meaningful estimate of how many people's data we have collected and how many U.S. persons' data we have collected, because to look at some small selection of it to make that estimate would harm privacy, it just doesn't make sense to me. The privacy, to some great extent, has already been violated. We're just trying now to get a gauge of how many people's privacy has been violated.
Mr. Salgado, you mentioned the prospect of different countries walling off their data or making an attempt to. How real of a concern, how timely of a concern is that? Have we seen such moves being taken by certain countries? Can you explain a little about that?
Yes, Senator, we have. So it's a very real threat. We've seen proposed legislation in jurisdictions to do just this. You've seen it in several flavors. There's the possibility of requiring data location, so companies requiring to exclusively store data within a jurisdiction. You see affirmative laws that are often referred to as blocking statutes, which would say companies that operate in this jurisdiction are not allowed to cooperate with U.S. authorities around data disclosure. So you see different flavors of these things. They all tend to start to create a network structure, an internet structure that is based on political boundaries, and the idea of a global internet quickly breaks down.
Well, thank you. That's a concern that I think a lot of us have, that this free flow across borders that's been so healthy and been necessary for the growth of this kind of communication would be disrupted. Mr. Rosenzweig, let me just get a general answer from you on this. Is the value of legislation like this, I can see the value in allowing companies to be able to explain more to their users and get greater comfort there. Is there as much value in this being an additional check on government not to go too far because they have to really reveal this information? What is the greater value in legislation like this, or is it shared that way?
I think the first principal value of the legislation is the one that Senator Franken expressed, which would be to statutorily mandate that which is now merely voluntary and an act of grace by the executive branch. So I think that that's regularizing that, institutionalizing that is a positive value. I think that in general, legislation that requires the government to explain itself is a positive value as well, everything from FOIA to Inspectors General statutes. My concern in particular would be to ensure that the disclosure requirements don't wind up disrupting the existence of heretofore undisclosed programs that are of value to us, and that I think I can't answer in a generalized manner. I think it's a very case-by-case specific manner I think that it's probably not a decision best left to the executive branch alone. I think it's a decision left to the executive branch in a classified discussion with this body and with the House of Representatives. It, by its nature, cannot be a discussion that, at least at the first instance, involves the American people, because that, by its nature, terminates the discussion itself.
All right. Thank you. That's been very helpful.
Thank you, Senator Flake. The Chairman Leahy has graced us and has arrived. I'd like to add this statement from the chairman to the record before, and I'd like to ask him to ask his questions.
Thank you, and I also take the courtesy of my friend from Connecticut, Senator Blumenthal. I think more and more people agree, or should agree, that we need additional transparency about our government surveillance activities. I think if we don't, we're not going to restore public confidence. And I think Senator Franken's work to build consensus around transparency legislation deserves praise. I'm glad that Google and other tech companies are lending their support to that bill. I think that the tech industry realized we need more than just transparency. We need some substantive reform. 7 of the major tech companies, and I'm reading to make sure I got them all right: Google, Microsoft, Yahoo, Apple, Facebook, AOL, and LinkedIn, signed a letter to me supporting greater transparency. They want substantial enhancement to privacy protection, appropriate oversight, and accountability matters. And I know Mr. Salgado knows that letter. I recently introduced a comprehensive surveillance reform bill. It's bipartisan, USA Freedom Act. And I appreciate these companies supporting stronger FISA work. Mr. Salgado, let me ask you, is just enhancing transparency, is that going to be enough to bring back global confidence in American technology companies? Do we need to do more? And if we don't do more, is this going to affect U.S. businesses?
No, thank you, Mr. Chairman. I think it's an important step to have increased transparency, but I do agree that more is needed than that. And as you noted, we've expressed our support for the legislation that you've offered. I think we need some reform that allows users and others to know that the intelligence community and its collection of data is done under law, that it's rule-bound, that it's narrowly tailored, that there is oversight, there's accountability for it, and of course, as we've been discussing today, that there is some transparency around it that can help bring some of the trust that all this is happening.
And aside from affecting the reputation of the United States, if we don't do that, it's going to affect businesses too, is it not?
Absolutely, Mr. Chairman, and in fact, we've already seen impacts on the businesses. I think Chairman Franken cited a couple studies in the opening statement that reflected some serious financial consequences. I think there's real concerns around the entire structure of the Internet over these revelations if this isn't addressed correctly.
Well, let me go a little bit on that. One of my biggest concerns about Section 215, phone records, is the legal rationale underpinning it has no limiting principle. If all our phone records are relevant to intelligence investigations, then why wouldn't everything be considered relevant? And if that's the case, the companies like yours concerned that consumers will not trust that their data is safe from unwarranted government intrusion. Does Google think about what that might do as far as cloud technology is concerned?
That's right, Mr. Chairman. The confusion that came out of as a result of the June revelations and since then, and additional stories, I think have led to a real concern both inside the United States and outside of the United States about what it is that's happening and what are the rules that govern it, what is the role of the FISA court, what are the decisions that are coming out of that court. All of those have played a role in the confusion and the need for some clarity.
Well, especially when NSA handles things so carelessly. They let a 29-year-old subcontractor walk off with all their secrets, and so far as I know, nobody's been even reprimanded for that. Mr. Bankson, what do you think?
Speaking generally, we think that transparency is critical to restoring trust in the U.S. internet economy and in the U.S. government itself, but that it alone is not sufficient, and that indeed substantive reform is necessary. CDT supports the bill that you have introduced, the USA Freedom Act, and we thank you for it. We look forward to working with you and the committee as it moves forward.
I'm worried about overclassification. I find oftentimes, and every administration has been guilty of this, it's easier to classify a secret than to classify a mistake rather than try to explain it. And let me ask Ms. Salgado, are you permitted to tell us whether Google's received any FISA court orders?
I'm sorry, Mr. Chairman, I would have to decline that answer until the bill that we're discussing today is passed.
Is our country safer because you can't answer the question?
I can't imagine the country is safer as a result of that.
Thank you. That answers my question. And Mr. Bankson, concerns been raised that company-by-company reporting on FISA might tip off those we're trying to track, but there's a lot of reporting available on criminal surveillance. Is national security related sufficiently different from criminal investigations? Do we have to have this kind of secrecy?
I don't believe so, Chairman, no. In the criminal context, we are often investigating sophisticated organized criminals and, in fact, sometimes investigating terrorists. And yet we have been able to publish, and the U.S. government has been able to publish, very detailed statistics about how the government is using its authorities, both the government as a whole and company by company, without any suggestion that that has harmed national security. And I just want to take the moment to address this issue of lumping all of those authorities together. I think that combining numbers for targeted FISA intercepts with FISA pen registers, with FISA orders for records, with FISA warrants for stored communications, with all the range of national security letters, and then combining that with all federal, state, and local law enforcement warrants, wiretaps, pen registers, subpoenas, and other court orders leads to such a useless number as to be actually detrimental. It's like asking a doctor to attempt to diagnose a patient by looking at his shadow. Only the grossest, most obvious abuse, if even that, would be evident.
And I apologize to Professor Rosenweg. I haven't had time. I will submit a question to the record, Mr. Bankston, on your argument that companies' First Amendment rights have been violated, the question of prior restraint, the Second Circuit case. Please take a look at the question. I really would like your answer for the record. It's important to me.
Thank you, Senator.
Thank you. And Dick, thank you.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman and Mr. Chairman. Thank you to both chairmen, and thank you all for being here today. I was interested in a number of your points, particularly Mr. Salgado, that additional measures are necessary, especially in response to Chairman Leahy's questions, to not only provide additional transparency, but also assure that individual rights are protected. As you know, I propose that there be a constitutional advocate to, in effect, provide some adversarial process within the FISA court. You know, as lawyers, courts make better decisions when more than one side is presented. Very few judges would permit a proceeding before them in which only one side is presented, because they know that the core principle of our judicial system is that it is adversarial and that the truth emerges as differing points of view, factual perspectives, and evidence are presented. And so that is one area where I think that the system can be made more accountable, if not more transparent. And as well, disclosure of some of the rulings and opinions of the court. Right now, it's a secret court that operates in secret, making secret decisions and secret law. One of the few, if only, courts in the United States where there is any secret proceedings of this kind, making secret laws. So let me elicit your comments on those kinds of additional protections to our constitutional rights from the perspective that you all have raised about our need for credibility and trust internationally in this system. After all, the means of communication, the internet, depend on international trust and credibility. Otherwise, it falls apart. So let me ask that somewhat open-ended question.
Well, thank you, Senator. I'm happy to take the first swipe at that. There are a number of proposals right now that are being considered, and that is a very good thing. And the general principles that there needs to be accountability and transparency with some oversight, and the rules are clear, are addressed by the various bills. Certainly, as an example, making sure that a court that's reviewing applications for surveillance has an opportunity to hear different ideas, different sides, that makes perfect sense, and it is certainly at the heart of most of the judicial proceedings we have in the United States. So that's something that I think makes a good deal of sense as far as a structural change to the current arrangement under FISA and the obtaining of FISA authorities. The same, of course, is true with understanding the interpretations of the law that the court applies to the different applications that come in. I think those are two good examples of the sorts of ideas that can help restore confidence that the system works.
I'm actually a fan of the idea of an advocate. But for slightly different reasons than I think than Mr. Salgado just said. The reason that we don't have an advocate in the search warrant application situation, for example, which is an ex parte application, or in a grand jury situation, is because those decisions are ultimately subject to ex ante review in a criminal proceeding, where there is a defense attorney who presents an adversarial view on whether or not the issuance of the warrant was with probable cause, or the grand jury subpoena was overbroad, or things like that. We lack that systematic check in the intelligence context because, of course, the intelligence surveillance rarely, if ever, results in a criminal prosecution in which that kind of adversarial process comes forward. So, to my mind, I would want to distinguish in allowing an advocate between those situations in which the FISA court were making some broad new systematic determination, an interpretation of law like the interpretation that gave us the relevance decision in the Section 215 law. I'd like to distinguish that from what I would characterize, and I admit the line is hard to draw, routinized applications of a settled law, where the value of an adversarial advocate would be much diminished, and the procedural difficulties that would arise from it, the costs involved, the time delay, might very well be adverse to national security. So cabined in that way and limited, I think that would be a perfectly fine idea. And as for the public disclosure, I would offer the exact same answer I gave Senator Flake in the other context, which is provided that we make sure that it doesn't wind up with the adverse effect of disclosing heretofore undisclosed programs that are properly classified, that would be as well an advancement in our understanding. Again, I admit that's a hard line to draw, and probably in both instances, the best answer would be to let the FISA court make that decision itself, to authorize the appointment of the advocate in the situations where it wants to, and to authorize them affirmatively or direct them affirmatively to make public disclosures when they think the disclosure of opinion would not adversely affect national security interests.
Thank you. The FISA court's job used to be pretty straightforward. It was a pretty straightforward statute based on some pretty straightforward Fourth Amendment jurisprudence, addressing some pretty straightforward technologies. Now we have the FISA court addressing an incredibly complex and broad statute in the form of the FISA Amendments Act. We have a rapidly complexifying technological landscape, and we have the FISA court, rather than simply making magisterial decisions, creating a body of common law on some of the hardest and most important Fourth Amendment questions of our time, sometimes in the face of what the court has described as misleading conduct by the lawyers in front of it. In that context, I do believe that it's critically important not only to have greater transparency regarding the decisions made by the court, but also to have an advocate in front of the court who is there to protect the people. And as such, CDT does support your legislation, Senator Blumenthal, and are working with your staff and with Chairman Leahy's staff on the issues that might bring to bear. So,
thank you all. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Not to speak for you, but I think that the way that Mr. Rosenzweig described the role of the constitutional advocate is very in line with what you envision.
Very much so. Thank you.
Okay. Well, thank you. I want to thank all three of you for your testimony. And in closing, I want to also thank the ranking member, Senator Flake, along with Senator Heller and Chairman Leahy, who have lent this legislation critical support. And of course, I want to thank all the witnesses, each and every one of them who appeared today. We've heard a lot of valuable testimony. There was a lot that I agreed with. There were some things that I didn't agree with, but I want to leave everyone with this thought. There is no question that the American people need more information about these programs. Just no question about that. For democracy to work, its citizens need to have at least a basic amount of information about the surveillance their own government conducts over their affairs. I think that my bill will give the American people that transparency. I'm looking forward to continuing to work with the administration and my colleagues to make sure that we're getting it right. We will hold the record open for 1 week for submission of questions for the witnesses and other materials. This hearing is adjourned.